Okay. Hi, everyone. Again, thanks again for joining us this afternoon for Ethical Considerations for Pro Bono Attorneys. We greatly appreciate your interest, and it's great to see you all this afternoon. Again, this CLE training is being recorded, and it is recording now. We will be requesting 1 hour of ethics CLE accreditation from the Oregon State Bar, and I will be sending that information out to everyone as soon as we receive the approval from the bar. As I mentioned previously, if anyone has any questions, please feel free to add those to the chat function, and we will be monitoring those questions. And with that, I just am so pleased and excited to introduce our two speakers this afternoon to you all. Many of you already know them. So Ed Johnson and Steve Walters are our presenters, and I'm just going to do a quick intro for those who have not met them before. So Ed Johnson is the Director of Litigation at the Oregon Law Center. He's been a legal aid lawyer in Oregon since 1996. For 5 years, Ed was a staff attorney at Legal Aid Services of Oregon's Multnomah County office, with a caseload made up of primarily housing and domestic violence cases. Starting in 2002, he has had a statewide position as the housing attorney in the state support unit of the Oregon Law Center. His work focuses on fair housing, subsidized housing, housing preservation, landlord-tenant issues, and homeless rights litigation. Ed is a 1993 graduate of Columbia Law School, and following law school, he worked as a litigation associate in the New York City offices of Kay and Scholler LLP for 3 years. And Steve Walters has been involved in litigation work for approximately 45 years. He spent most of that time in private practice with tall building law firms in Portland and San Francisco. He's tried more than 100 cases to verdict, approximately 60% of which were jury trials lasting anywhere from 1 week to 4 months. Steve got his start in legal aid as a VISTA volunteer in the Blue Ridge Mountains of Georgia, where he helped organize and work for a small program, named Georgia Mountain Legal Society, and worked for 3 years as special assistant to the president, deputy general counsel, and acting general counsel, and then brand new Legal Services Corporation. He's worked in the state support unit for 8 years, where his job title has had something to do with litigation. He's a member of the American College of Trial Lawyers. Steve graduated from Stanford University and its law school, and then was a law clerk to Judge Ben C. Dunaway of the Ninth Circuit Court of Appeals and to Chief Justice Werner Berger of the United States Supreme Court. So with that, I turn it over to Steve and Ed, and just thank you so much for presenting it to us this afternoon, and thanks for you all for joining us.
So I think, first of all, I just want to thank everyone for coming to this and for being a pro bono lawyer. I know your time is super valuable, and the fact that you're willing to take cases pro bono really helps, obviously, the low-income folks that you're representing, but also helps us meet our mission. So I really appreciate that, and I want to thank you for the work you've done on those cases. I think the plan, Steve and I are coming off of what we called Ethics Week last week at Legal Aid, where we did 5 hours of ethics training for OLC and LASSO attorneys. And we're going to try to give you a couple of greatest hits from that. They were issues that I think generated a lot of discussion in our trainings last week, but feel free to pipe in with things you're interested in, and we'll do our best to answer questions. If you're not speaking, please mute yourself. We've learned there's a lot of echo issues on Zoom. I guess 2 years in, we're all learning how Zoom operates. And you can either just raise your hand or throw something in the chat if you have questions, and we'll pause periodically to see what kind of questions we have. So I think Steve's going to start us off. I will just say before I hand it over to him that I spent probably 20 of the 25 years I've been a legal aid lawyer generating ethics questions. And for the last 4 or 5 years, it's also been part of my job to answer ethics questions along with Steve. But having Steve in the office next to me has made that job a lot easier. He's got a lot of experience sorting through these issues, and I always appreciate his counsel on these. So Steve, you want to start us off?
Sure, thanks. Thanks for the kind words. And also, I'd just like to echo what Ed said about how we appreciate you pro bono lawyers for taking cases for our clients. It's a big part of what we're able to do for clients and for our mission. The first topic I'm going to talk about is one that comes up with considerable frequency. And it sounds like it's pretty straightforward, and that's the principle that I think everyone knows, that you're not supposed to talk directly to a person who is represented by a lawyer. As I say, it sounds fairly straightforward. But as with so many of the things in the ethics area, and I suppose the law generally, the devil's in the details. And that admonition about talking directly to someone who's represented by a lawyer there's both more and less there than meets the eye. So I'm going to walk through some of the features of that principle, and just for those of you who are keeping track, this is in Rule of Professional Conduct 4.2, which is dealing with represented parties. The first thing I want to talk about are the elements of the prohibition on direct communication with represented parties. First of all, you need to know the person is represented when you talk to them. And that's kind of an important point, because know in this context, in the rules of professional conduct, means actual knowledge. You have to actually know. It's not a negligence standard of, well, you knew or should have known or could have known or whatever. So you had to have actual knowledge. Now, actual knowledge can be inferred from the circumstances. So it could be pretty obvious that the person is represented and that you knew that, and that can be inferred. But again, it's an actual knowledge standard. So while it is always a good idea to ask someone, are you represented by a lawyer on this? And many of the lawyers in our programs will begin, for example, demand letters to potential defendants with, if you are represented by an attorney, please send this letter to that attorney. That's a good practice, but it's not necessary if you don't know that they are represented by an attorney in this matter. The second qualification, or the second element of this principle, is that the communication has to be with respect to the representation has to be with respect to the subject matter of the claim or issue that you are representing your client on. And so a person could have 10 or 15 lawyers, but if you don't know they're represented on this issue, like you're an FED, then you don't know that they're represented by a lawyer, and the communication isn't just on its face prohibited. And someone may have a securities lawyer and a bankruptcy lawyer and 40 other lawyers, but if you don't know they're represented on the FED, then you don't violate the rule by having contact with them. Although again, it's a good idea to say, if you're represented by a lawyer, turn this over to the lawyer. Now, the subject matter of the litigation, though, or your representation, isn't just with respect to your case. A common example that comes up in practice at both OLC and LASSO is, for example, when you're representing a domestic violence survivor in trying to get a FAPA, trying to get a restraining order, there will be a parallel criminal case that has been brought against the abuser, arising out of the same transaction. And while the abuser may be pro se in your restraining order opinion, they're more than likely represented in the criminal matter. They'll have a public defender or someone like that. That public defender or that lawyer in the criminal case represents them on the subject matter with which you're dealing, because those are the circumstances of the abuse. And so you can't talk directly to abuser with respect to your FAPA, you need to at least get clearance from the criminal lawyer. Now, most criminal lawyers will tell their client to take the fifth and not let them talk to you. But we've had instances where the criminal lawyer said, "Sure, go ahead, it doesn't matter." But if you know someone has some type of criminal proceeding pending, that your first move should be to have a conversation with the lawyer who represents the person in that, even if they're pro se in the case in which you are involved. The third element of this is you cannot communicate directly with the represented party without the lawyer's consent, the consent of the lawyer who represents them. That lawyer can consent to you having conversations directly with her or his client. I'm not sure why a lawyer would do that, but that's an exception in the rule. But remember, it is the lawyer's consent. It isn't the consent of the represented party. So if you get a call from a landlord, for example, in a case, housing case where you're representing a client, and the landlord calls, and you know that person's represented by counsel, and says, "It's all right, my lawyer said it's okay for me to talk to you, and I don't want to run up the fees for having them talk to you, so I'm just going to talk to you directly." You say, "Sorry, hang up the phone and call their lawyer." The consent has to come from their lawyer, not from them. You need to be very, very careful about that, because some people are, some represented people are rather loosey-goosey about those things, and again, want to save hourly fees or whatever. It is not required that the lawyer's consent be in writing. It can be oral consent. You can have a telephone conversation. They say, "Sure, go ahead." Again, I don't know why, but they might say that. But if that happens, make sure you get a writing. It doesn't have to be in writing, but you can't be too careful with this prohibition because the bar takes it very seriously. And so at least shoot an email to that person saying, "Confirm our conversation. You said it's all right for me to talk to your client about X, Y, Z." Be extra careful when you're, if you're able to get a lawyer's consent to talk to their client. The last point about the elements of RPC 4.2 is that you cannot get a third party to have a direct conversation with a represented party when you are barred from doing that yourself. Example would be an investigator. You can't send an investigator to talk directly with the represented party, and the rules and the ethics opinions are really clear on this. This also applies to your client. Now, I'm sure most folks know clients can talk to each other at any time. There's no prohibition on that. So your client could call the landlord, whomever on the other side, and talk about the case, try to settle the case. Happens not infrequently that two individuals trying to settle a case to which their parties have more success in doing that than when the lawyers are doing all the talking. But it's okay for your client to do that, but you can't tell the client what to say or positions to take. If you're doing that, that's a communication that you're having another person transmit, and you're in violation of the rule. So be very careful about that. If your client says, "I want to talk to the landlord or talk to the person on the other side," you can say, first of all, you can do that. Be careful if you do that, but you can't tell them. But so I suggest you say A, B, C, D, E, F, G if you're going to try to reach a settlement. That's just the same as if the communication came from you directly, and it's a violation of the rule. Are there any questions about this, what I call the elements of the rule? Cool. So the next part of the prohibition on direct communications with a represented person is who is a represented person. Seems simple, but there are some complications to it. Obviously, if the opposing party is a person, an individual, a human being, then you can tell who is the represented person or persons if there are all individuals. It becomes a little more complicated when you're dealing with an organization or an entity, a corporation, a partnership, an LLC, a trade association, or something of that sort. The question comes up of who is represented and who isn't within that organization. And the rule is fairly bright line on that. And there are ethics opinions that the bar has made very clear. If you are talking to people who are currently employed by the corporation, you can not talk to officers, directors, or managers. Basically, people who speak on behalf of the corporation. Those people are considered represented by the corporations or the LLCs or the partnerships lawyer. In addition, people are considered represented by the organization's lawyer if their conduct is at issue in the litigation. And that's, for example, it might be a low-level supervisor or someone of that sort. But if your case is, for example, this supervisor sexually harassed my client, and I'm saying that the organization is responsible for that conduct, that person's actions are at issue in the litigation, and you have to treat them as represented as well. So again, but beyond those categories of people, you can talk to any current employee you want to, as long as they're not officers, directors, managers, or a person whose conversation conduct is at issue. You can call up the people your client tells you, this person knows about it, this person knows about it, this person knows about it, and you can talk to them even if they are current employees. The other side of that coin is former employees. You can talk to anyone. If the former CEO of the corporation wants to rat the corporation out for all the terrible things they've been doing, you can talk to that person. Same thing if they were a former director or former manager or something of that sort. Former employees are fair game regardless. However, you need to be careful because many lawyers who represent corporations or LLCs or whatever will claim to represent everybody, the former employees who might have knowledge and that type of thing. So I think that's kind of bad faith. I think that it can lead to conflicts on their part, but some lawyers will assert that. And so you need to be careful if they're saying, you can't talk to anybody, I represent them all. And then you have knowledge and that sort of thing. But beyond some sort of action like that, you can talk to any former employee you want to talk to. One caveat for both current and former employees: when you talk to them, you cannot ask them about things that have been told. They have been told by the organization's lawyer, things that were that would be attorney-client privileged communications. Sometimes the lawyers will have conducted an investigation, will have talked to various employees during the course of the investigation, and you cannot inquire about that. And if the former or current employee to whom you're talking says, well, the lawyers came around and they were saying you need to stop them, because you cannot infringe on the attorney-client privilege even when you're allowed to talk directly to people. The last point about dealing with represented parties is that even when you can talk to somebody, again, most current employees, all former employees, even when you can talk to them, you have to follow RPC 4.3, which is the rule concerning dealings with unrepresented parties. And there are basically three parts of that. Number one, if you're talking to like the former CEO or current lower level employee, you need to be clear that you are interested in the matter you're talking about, and that's sort of a catchword to say you've got a dog in this fight. You're representing a client. Sometimes it happens you're representing your own interests. More likely, it's when you're representing a client, and you need to make clear, I represent someone in this. I have an interest in this conversation. Number two is if during the course of the conversation there appears to be a misunderstanding on the part of the person you're talking to about what your role is, you have to correct it. And I suppose an example might be if you're talking to a lower level current employee, that person says, I'm really glad you're taking this on. I'm glad you're investigating all of the things that they have been doing, and you're going to help us out on in this case. You need to say, well, excuse me, I represent X or Y. I'm not your lawyer, is what you have to make clear when you're having these conversations with them. Number three, when you're dealing with an unrepresented person and you have reason to believe that your interests might be adverse. For example, they may be a witness for the company. They may have been in conflict with your client. Anything of that sort that may mean that their interests are adverse, you cannot give them legal advice. So, they may ask you, but well, what does the law say about this and what does the law say about that? All you can tell them is, that's a great question. You need to get your own lawyer, because I can't answer the question. And in one of our sessions last week, we were doing a deeper dive into the dealing with unrepresented parties issue. And in the context of when you have a pro se opponent, because the 4.3 applies to dealings with pro se opponents because they're unrepresented parties. And when what you're saying is legal advice, and what you can say and what you can't say gets quite complicated. I'll put it that way. At one point during the session, I think people were bringing out torches and pitchforks for what I was telling them about what they could say and couldn't say. But at any rate, you can't give an unrepresented party who may be adverse to your client legal advice. They may ask, but you need to tell them, just get your own lawyer. So I saw something popped up in the chat, and maybe
Would you like me to read that to you? It's from our friend Damian Munsinger. He writes, what do you recommend for the mechanics of talking to former employees? Do you owe the corporate attorney a heads up so that they can assert that they represent everyone? Or do you recommend reaching out directly to the former employee and asking them if they are represented by corporate counsel?
I would do the latter. You don't have to call another lawyer. I mean, you know what's going to happen if you call the other lawyer. The lawyer is going to say, I didn't before, but I do now. And so all you have to do, if you don't know they're represented, you can, if the lawyer hasn't told you, I want you to know I represent everybody, you can call that person, you can ask them, are you represented? And if they say, no, I'm not, then you can have the conversation, as long as you comply with RPC 4.3. But you don't, it's not a courtesy, not anything. Do you have to let the other lawyer know? And in fact, I mean, this is part of your work product. And so you really have no obligation to let the other lawyer know. Any more questions on that? Thank you all for your attention. I'll turn it over to Ethical Ed.
That's a new nickname. That frightens me. Okay, so I'm going to talk a little bit about conflicts, and I'm going to try to spend most of the time on the tricky stuff that we spend a lot of time spinning out and analyzing at Olsey and Lasso. I wanted to back up for 1 second, though. This came up last week, and I don't know, I suspect people on this call are familiar with what the main sources of ethics law in Oregon are, but we got several questions about that last week. And so, you know, I just go to the bar website to start with when I have an ethics question, and I always start with the RPCs. I know a lot of you have been practicing for a long time, and there's something about the RPCs that doesn't lend itself to memory very well. Maybe there's a lot of vague terms in there. And so every time I get questions, especially around former client conflicts, I reread that rule. And then I look at the formal ethics opinions also on the bar website, which are, I think there's a way to search through those, but you know, there's fewer than 200 of them, and you can kind of quickly look through that list, and they're, you know, the list itself is sort of clear when it's like generally in the topic you want, but there are lots of ethics opinions about conflict issues because they come up a lot. So, and then of course there are reported decisions, you know, disciplinary decisions.
There's also in bar books, there's a publication called the Ethical Oregon Lawyer. The last revision was in 2015, so it doesn't have everything about that, but it was written by Peter Jarvis and Mark Fuchelli and someone else. These are sort of the most notable ethics lawyers in Oregon, and they have a series of blurbs. Some subjects they treat at length, some of them they just give you a blurb, but they give you some quick analysis and some citations to opinions and cases and that sort of thing, which so it's a good quick way to have a look. But I agree with that. I would start with the RPCs themselves and then check them out. And you can search the ethics opinions and the Ethical Oregon Lawyer for a specific RPC.
Okay, so I'm gonna just try to hit some of the main points about conflicts. I mean, I assume when you get a pro bono referral, the first thing that you or your firm does is run a conflict check. And, you know, that's the same first thing we do when we have a new prospective client as well. The rules that you're looking at with conflicts are RPC 1.7, 1.8, and 1.9 primarily, plus a bunch of formal ethics opinions, as I mentioned. And I want to spend most of the time on former client conflicts because they're the hard ones usually. But we do have a fair number of questions about current client conflicts, and Rule 1.7 sets out the rules. You know, generally comparing Rule 1.7 about current clients and Rule 1.9 about former clients, the two main takeaways are that the more things are going to be conflicts for current clients, and some of them are not waivable. So former client conflicts, the rule's a little bit more flexible, at least on its face. But with regard to current client conflicts, there are certain situations where you can't represent the new person. When I talk about conflicts, I sometimes use case number one, case number two, and client number one and client number two. But ideally, really, when you're analyzing a conflict, you don't have client number two yet. Client number two has come to you as a prospective client, but you haven't accepted that case yet because you're in the process of analyzing the conflict. I know from answering ethics questions for several years now, it doesn't always happen in that order, but that's the order it's supposed to happen in. So that's the terminology I'm using, but client number two hopefully is usually not a client yet. So if client number two comes to you and you have an open case for client number one, and that person is directly adverse to client number two, that's your easiest conflict question. That is a conflict, and it's not waivable. The next kind of non-waivable current client conflict is not directly adverse, but there's a significant risk that the interests of the two parties may be materially adverse. And that's a phrase that pops up in 1.9 as well. And I'll talk about it in a minute in the context of former client conflicts, but that's a little fuzzier of a term. But in terms of current client conflicts, if it appears that your current client number one has a materially adverse position to potential client number two, that is going to be a conflict that you're not going to want to take case number two, and it's not waivable in that situation. So the second part of current client conflict rule has to do with situations where you have decided, you reasonably believe, having looked at these two cases, that you can represent both of the parties without harming the interests of either one of them. In other words, you've determined that there is no significant risk that the interests of the two parties are materially adverse. In that situation with current clients, you can proceed if you get informed consent confirmed in writing from each party. So I should have said this up front, but it comes up right here, which is with current clients, the fact that you've gone through this analysis and current client number one has come up in some context should give you pause. Unless current client number one is actually aligned in some way with current client number two, there may very well be a future conflict lurking there. And the sort of unwritten rule about conflicts that we use is that when in doubt, if it doesn't feel right, don't take case number two. There are no ethics penalties for incorrectly assessing that there might be a conflict and not taking the case. Whereas if you incorrectly assess that there's not a conflict and you do take the case, that can have serious repercussions for both clients and for you. And so the safer bet in these situations is always to not take case number two if it doesn't feel right or you see a looming future conflict. So that's kind of the backdrop of this. But of course, the conflicting interest there is that a lot of times the attorney really wants to take case number two. It's a compelling case. At Legal Aid, we often are in a position where if we don't take the case, nobody else will. And so it has real repercussions for client number two if we're overly conservative about the conflict analysis. And so we often do go through this analysis and we often do take both cases, but we proceed cautiously with these. So the phrase informed consent confirmed in writing pops up in the rules in a few places, including both Rule 1.7 and 1.9. And I just want to make sure that everyone's aware of rule number one. I don't know if it's like the First Amendment, it's first for a reason, but RPC 1 actually defines a bunch of these terms, and it defines what informed consent confirmed in writing means. And, just kind of talking through it to try to, sometimes the RPCs use language that doesn't, sometimes the definitions raise more questions than answers. But, my interpretation of those definitions is that you don't inform a client by the writing itself, right? I mean, the nature of that phrase, informed consent, confirmed in writing, means that you've spoken with the client about the conflict and informed them about the pros and the cons and the potential of a future conflict that could come up. And you've sort of talked through various scenarios and answered their questions. I mean, a lot of times our clients are not sophisticated litigants. Sometimes they have impairments that requires quite a bit of talking before you feel comfortable that they've given informed consent. After you've gotten informed consent from the client verbally, you send them a letter that says they should seek outside counsel about that issue and asking them to sign it before you proceed with their representation. So really the writing is the last part of the informed consent process. So does anyone have questions about that kind of introductory stuff? And then I'm going to turn to former client conflicts. Well, you all are shy compared to legal aid lawyers. I can tell you who was not shy. It was our colleagues last week. They had a lot of questions about this. So
Just let me ask something sort of rhetorical, Ed. It's when you send the second letter, the one that to get the consent, do you sort of outline the advice that you have given them about pros and cons in that letter?
yes, I put it all out there. And so, and we, you know, a lot of times there's similar situations. And so we kind of have form letters that we operate off of that are all inclusive, but I modify them for the discussion that I've actually had with the client. So thank you for that softball question.
Sure.
Your leading question. I always like questions where that suggest the answer to me. Okay, so let me let's see what happened here. I think I just minimized all of you. So turning to duties to former clients, it comes up a lot. I mean, I would say weekly we have a situation where Lasso and Olsey have represented thousands and thousands of people. And so, you know, there are situations where someone, you know, former client pops up in some context when we're evaluating case number 2. And, you know, RPC 1.9 sub A is the roadmap that we use to walk through these, but they're really fact specific. And, you know, there is no one size fits all answer to these questions. You really have to kind of grind through the details of the former representation and what the current prospective client is seeking. But in general, as I said, the rules are a little more relaxed. And if you do have a conflict, it's theoretically going to be a waivable conflict with the former client. Now, there are many situations in the areas of law that we practice where the former client is never going to consent, and nor should they. And there are times when we don't really seek it because it's too much of an adverse situation. But the rules do allow you to attempt to get clients to waive conflicts in situations with former clients. And so I just want to walk through this rule and try to hit some of the places where we spend a lot of time analyzing whether there's a conflict. So the first, when you're looking at whether or not you have a conflict, the question that you're asking yourself is whether you're about to represent another party in the same or a substantially related matter. That's one phrase that we fixate on, in which that person's interests are materially adverse to the interests of the former client. And materially adverse is the other phrase that we spend a lot of time trying to sort through. So starting with materially adverse, the easiest situation is your former client is the opposing party in case number 2. That is materially adverse. You can rest assured you have a conflict there. The trickier situations, and there are an infinite number of permutations about how this comes up, but it's when your former client pops up either as part of the conflict check or just in your investigation or initial meeting with client number 2 as someone who is aligned with the opposing party in case number 2. It could be a family member, like a spouse. It could be that client number 1 is going to be a star witness for the opposing party. Those are all situations where you should be thinking at least that the positions are materially adverse, and you need to go walk through, you know, the details of that. But the situations where your former client is aligned with the opposing party in case number 2 is where you're going to be moving to the next part of the analysis, which, you know, I feel like it's always a strange situation where a group of lawyers write something and then a group of other lawyers are trying to figure out what they meant by that. And this is certainly one of those situations where hours and hours have been spent trying to unravel the phrase "the same or substantially related matter." And so I will say that the same matter is the easy part of that. I mean, matter is defined to be very narrowly to literally mean the same case in most situations. And so you should be able to figure out whether the interests of the two parties are materially adverse and part of the same matter. That comes up sometimes with an appeal or a remand or whatever, where it's literally the same matter. Substantially related matter is the tricky one. And the way that I tried to explain it last week, and then I've tried to explain it in the past, is that eviction case number 1 is not the same matter as eviction case number 2. Divorce number 1 is not the same matter as divorce number 2, but it certainly could be substantially related. So for better or worse, we have a definition of substantially related, which is found, I think, in sub D of 1.9. And it, like many RPCs, answers some questions and raises some more questions. But it does provide a roadmap. So there are 2 ways that matter 1 can be substantially related to matter 2. The first one is sort of intuitive. The lawyer's representation of the current client will injure or damage the former client in connection with the same transaction or dispute that was the subject of the former representation. So I will just note the obvious, that the phrase same transaction or dispute is different than the phrase same matter. And sure enough, the formal ethics opinions kind of spin that out in different scenarios. And there's one really helpful ethics opinion, at least it was helpful for me. I think it dealt with drafting a will, and then the second client came in. But what the ethics opinion says is that the lawyer should not run the risk of undoing the work they did in case number 1 in case number 2. So that's kind of a way to think about it. So going back to the eviction analogy, eviction A may have been a case where you represented client number 1 in maintaining their housing. And maybe a year or 2 passes and eviction case number 2 comes in from a separate client in the same housing complex. And that person's being evicted because the landlord is alleging that they started a fire in the housing complex. And prospective client number 2, you learn that client number 1 is going to be the landlord's star witness, because former client number 1 claims that he saw client number 2 start this fire. And you learn from prospective client number 2 that not only did client number 1 not see that, but client number 2's position is that client number 1 started that fire. That is substantially related, because if you embark upon helping client number 2, there's a very high likelihood that client number 1 is going to be evicted from the very housing that you helped him maintain a year or 2 ago. That's a fairly easy example, but you can imagine scenarios that are closer to the line about whether or not they are substantially related, and whether you may be harming client number 1 by taking case number 2. The second part of that definition of whether a matter is substantially related is not so intuitive. And it kind of gets into the area of client confidences, which I'm not really going to talk about today, but other than to say, it's a good idea to keep client confidences. One of the things about reading the ethics opinions about lawyers who violate client confidences is you don't want to be in the position of trying to fit your decision to divulge a client confidence into one of the narrow exceptions to that. But remember that this part 2 of what is or isn't substantially related is part of the conflicts analysis, not part of your obligation to keep information confidential, although it's clearly overlaps and relates to that. So part 2 says that there is a substantial risk that confidential factual information as would normally have been obtained in the representation of former client would materially advance the current client's position in the new matter. So, there's kind of two ways to look at it, but the way I look at it is you can't take case number 2 if you would have learned information that would have been helpful to that case in case number 1, and you can't use it on client number 2's behalf because it's confidential. I mean, that's sort of the logical extrapolation of the conflict analysis there. I will note that the language of the rule is clear that it's not the information that you actually obtained in representation of case number 1. It's the kind of information as would normally have been obtained in the representation of the former client. And some of the ethics opinions follow that logic and speak of it as though it's the information that you would normally obtain. And other ethics opinions talk about it as though it's the information that you actually obtained. So I don't know exactly what to make of that, but usually when we are analyzing these cases, we don't know exactly what information was obtained in case number 1. And so the analysis that we're doing is, whether or not in the course of representing client number 1 in a divorce and child custody matter, would we have normally gained the kind of information that would be helpful to client number 2 in her eviction defense or her, SSI case or whatever it is. And so you can see how that analysis becomes sort of complicated because you have to talk through what sort of information would you normally have obtained and how could it hypothetically be helpful to client number 2. And so, I think I'll just leave it right there. Do people have questions about that conflict analysis? Do you see any questions, Steve? I've completely lost the screen.
I don't see any questions. I was just going to ask you on the whole issue of client confidences. Does it, if you got something in confidence, and can you say, well, I can use it anyway because it's publicly available information, like you found out client from representing client number 1, their extensive criminal history, for example, for arson in the who set the fire case. Can you say, well, that's a public record, so I can go ahead and use it?
I would not do that. No, although there is an exception if the piece of information is widely known, but there's a recent Oregon Supreme Court case from last fall that I recommend reading because it gives you, the takeaway from that opinion is that you do not want to be divulging former client confidences in any context, and then later coming up with an argument for why you were allowed to do it. But this was a situation where a former client of a lawyer posted some criticism of the lawyer's lawyering on an online forum. And the lawyer decided to respond by identifying the former client and the former client's criminal history, which I will say when I just read the facts, I was like, yes, that's unethical. That's going to be a problem. But then when you start to read that attorney's defense to why he was allowed to do that, part of it was that, someone's criminal history is widely known and is public record. And the Supreme Court basically said, it may be true that someone could do a public records request to get that information, but in the context of where this communication, where this confidence was shared, this online forum, that was highly unlikely. And so essentially what the lawyer was doing was divulging a confidence that otherwise would not have been widely known or available to the people who were reading these comments on the online forum. So no, you cannot do that. I would not do that. So we have another 10 minutes if people have questions. I don't know if there's any other, there's a lot of things we could talk about here for a few minutes. I was thinking I would say a couple minutes about positional conflicts, Steve.
Sure, go ahead. That's a good idea.
Okay. It's an interesting conversation at Legal Aid because, you know, we're the kinds of cases that we focus on, you know, we're usually on the same side of cases. We're usually representing tenants in housing cases against landlords. We're usually representing survivors of domestic violence against perpetrators of domestic violence. And so, you know, when we look at positional conflicts, it's in that rare situation when we may be on the opposite side of a case for one reason or another. But, you know, for folks in private practice, I think it comes up in all sorts of different contexts. And there are very few situations where there's actually an ethical conflict. And basically the rule on positional conflicts, you know, is that you can't, it comes out of rule 1.7. You know, you don't want to take a position that runs a significant risk of, you know, materially harming the interests of client number two. And so the example of that is you've got two cases, and in case number one, your client wants you to say the statute says X, and in case number two, the client wants you to say that the statute says the opposite of X. According to the ethics rules, there's a lot of situations where you can do that, but there are two situations where you cannot do that. One of the cases is in the Court of Appeals or some other case where the decision is going to be dispositive, is going to have a direct effect on the other case. Because if you win in that case, there's a high likelihood you're going to be losing in the second case. Also, if you're in the same trial court, in front of the same judge raising the opposite, that's a situation where you have a 1.7 current client conflict. But there's a whole host of other scenarios that really don't fall into that fairly narrow prohibition. And, you know, I think in private practice, they're known widely as business conflicts where, you know, if your firm is known for representing corporations, you may not want to do a lot of shareholder disputes against corporations because you could make bad law, but you also are going to scare away clients. And so we, you know, at Legal Aid, we call them mission conflicts where, you know, we don't want to be in a position where we're arguing that, you know, FAPA is unconstitutional, for example, because that would really harm a lot of current and future clients down the road. Even though it may not violate the conflict rules. And so, so I just wanted to flag that there used to be a model rule, an ABA model rule that dealt directly with positional conflicts, but that has been rescinded, and the rules now just kind of rely on whether you have a 1.7 current client conflict. Okay, any questions about that? I believe we have spoken long enough to, yeah, go ahead.
Hi, this is Alan Aldis. I've a volunteer for LASSO, and if I talk to a client and then it's confusing whether they're a client of LASSO or a client of me. And then second, so they tell me something, how much can I share that with other attorneys in LASSO?
So I would have to look at the pro bono retainer, but you know, the client, at least on the front end, is a LASSO client initially as they're moving through our pro bono. Correct me if I'm wrong about this, Jill. And so I think when the client becomes a client of yours probably has to do with, you know, when you tell that client you're going to do something for them and they have a reasonable belief that you're their lawyer, certainly when you sign a retainer agreement. But at least on that front end, you know, I think it's a client of LASSO, and anyone you talk to at LASSO is going to be covered by the attorney-client privilege on that front end. Does that sound right to you, Jill?
And I can just add also that the sample retainer agreements that we provide to our volunteers on all of our pro bono cases, it has a built-in release just for that purpose, so that the client is, you know, providing you permission to kind of ask Lasso questions or about the case, or if you're needing help or any type of guidance. So that is one of the benefits of utilizing the retainer agreements that that Lasso provides.
And then does the client agree to that retainer agreement when they, like for the senior project, does that client, I mean, is that when we first talk to somebody, are they considered a client of Lasso, or are they a prospective client, or how does that work?
I would think they are a prospective client at that point. Yeah, their perspective. I mean, you still, as you know, have obligations of confidentiality to prospective clients, and the information that they give you during your assessment of whether or not to represent them is confidential as well.
Okay, so they have not yet agreed to the retainer agreement.
Right.
When they're prospective, and but I could still share what they tell me with other attorneys in Lasso.
Yeah.
Okay, thank you.
Yeah, presumably Lasso's done an intake already, and so
Yes.
I see it on to you.
All right. Anything else? It's great seeing you all.
Wonderful. Thank you so much, Steve and Ed, for sharing your expertise with us this afternoon. We really appreciate your time. And thanks to you all for attending and your ongoing continued support for legal aid pro bono projects. We greatly appreciate your support. So thank you very much.
Yes, indeed. Thank you.